The Court observes that customary international law imposes a duty on all parties to an armed conflict to allow and facilitate rapid and unimpeded passage of humanitarian relief for civilians in need. Any large-scale diversion of humanitarian aid constitutes a violation of obligations under the Fourth Geneva Convention. The occupying power may never invoke reasons of security to justify the general suspension of all humanitarian activities in occupied territory. Relief schemes must be carried out in a manner that respects the dignity of the local population and that is consistent with the protection of the human rights of that population. After examining the evidence, the Court finds that the local population in Gaza Strip has been inadequately supplied. Israel alleged that UNRWA has been infiltrated by Hamas and other terrorist organizations, and that UNRWA employees took an active part in carrying out the attacks of 7 October 2023. Israel further alleged a widespread and systemic misuse of UNRWA's assets and facilities by Hamas. The Court considers that the information before it is not sufficient to establish UNRWA's lack of neutrality. In addition, the Court finds that Israel has not substantiated its allegations that a significant part of UNRWA employees are members of Hamas or other terrorist factions. The Court further observes that Israel itself has not ensured that the population of the Gaza Strip is adequately supplied. The Court recalls that in addition to severely restricting the entry of aid at various times after 7 October 2023, Israel blocked the delivery of humanitarian aid in the Gaza Strip starting from 2 March 2025 and only allowed the delivery of a limited amount of aid to resume on 19 May 2025. The evidence thus shows that whether or not the operations of the United Nations acting through UNRWA were replaceable, Israel had no replacement system mobilized for a 10-week period. The Gaza Humanitarian Foundation, a purported replacement for UNRWA, has been widely criticized by the United Nations and other international actors, and its operations have been alleged to be inconsistent with core humanitarian principles. The United Nations observed in its response of 27 August 2025 that aid delivery remains significantly below the volume required to meet the needs of the population. According to the Office for the Coordination of Humanitarian Affairs of the United Nations, to which I shall refer as OCHA, over 2,100 Palestinians have been killed at or near the distribution sites of the Gaza Humanitarian Foundation since that system began operating on 27 May 2025. The Court concludes that in the present circumstances, the United Nations, acting through UNRWA, has been an indispensable provider of humanitarian relief in the Gaza Strip. The Court considers that Israel is under an obligation to agree to and facilitate relief schemes provided by the United Nations and its entities, including UNRWA. The Court recalls that Israel, as an occupying power, is not entitled to sovereignty over or to exercise sovereignty powers in any part of the occupied Palestinian territory, including East Jerusalem. By enacting and enforcing the two laws adopted by the Knesset on 28 October 2024 that unilaterally terminated Israel's cooperation with UNRWA, including its operation in East Jerusalem, Israel continues to exercise sovereign power in East Jerusalem. Moreover, these laws have directly resulted in obstructions to the operations of UNRWA in and in relation to the occupied Palestinian territory, in particular in the Gaza Strip. In the view of the court, Israel is not entitled to withhold its cooperation with the United Nations by unilaterally deciding on the presence and activities of the United Nations entities in and in relation to the occupied Palestinian territory